Okay, welcome everyone. Good afternoon or good morning or good evening, depending on where you are located. We're going to open our session today with a welcome. I'm going to hand over to Margaret Vidar from FAO.
Is this on? Yes. So welcome. I'm from FAO, the legal office, and I've been working in development law for some years now. In FAO, we have had a wide relationship with human rights. We didn't talk about it for some time, and we were very active in the 60s. FAO actually proposed a language that became the paragraph 2, Article 11, the International Covenant on Economic, Social, and Cultural Rights on freedom from hunger. And FAO changed its constitution at the same time to recognize humanity's freedom from hunger as a special purpose. But in the 60s, we had this big campaign, Freedom from Hunger campaign. But then the Cold War sort of got colder, and it became more difficult to speak about all human rights, whether socio-economic rights or civil and political rights, until the mid-90s. So basically, we didn't take it up again until 1996 with the World Food Summit asking for action on the right to food. And in that time, we concluded some exchange of letters with also the High Commissioner on Human Rights. We organized some workshops to understand better what we were talking about, and we in FAO contributed to what became General Comment 12 on the right to food. A little bit later, we had the first negotiated document in FAO, the Right to Food Guidelines, adopted almost 20 years ago. And this was followed by other documents adopted by the Committee on Food Security on governance of tenure and on responsible investment in agriculture. There's a lot of other things. But about 10 years ago, we had the Committee on Fisheries adopting a small-scale guidelines, so that is all part of the same development, if you like. Now, during this time, we have had various cooperations with human rights bodies, but it's been, I have to say, a little bit unsystematic, a little bit sporadic. So sometimes it's been strong and sometimes it's weak. It sort of depends on what's going on, depends on the persons on the other side, and it doesn't always gel, but sometimes it does. So I think today's session will be useful for FAO to start thinking about how to more systematically exchange with human rights bodies, whether it is also the High Commission for Human Rights or the various committees and treaty bodies, to see if we could become more systematic. We've been trying for 25 years, so don't keep your hopes. But with that, I'd like to again welcome you all to this human rights training event. And I'd like to hand over to Eileen for moderating the event. Thank you.
Thank you very much, Margaret. So I'll introduce myself first of all to everyone in the room and on screen. My name is Eileen Webster. I'm from the University of Strathclyde, and I'm a researcher in the One Ocean Hub. And I'll be helping to moderate the discussion today. This is our first hybrid meeting in this location, so please bear with us if there are any technical issues, and please send a chat message to let us know if there are any problems. We have quite a lot to fit in today. We don't have a break planned, so please feel free to leave as you need. I'm going to get straight to it and invite our first speakers to contribute. So we're going to hear from Carol Rask, Chief Advisor in Human Rights and Development at the Danish Institute for Human Rights, Elisa Morgera from the University of Strathclyde, who is the Director of the One Ocean Hub, and Anna Suarez-Dusan, who's a human rights specialist in relation to fisheries at FAO, and they're going to be discussing various aspects of international standards and connections between them and national standards and actors. So, Carol, you have the floor.
Thank you very much. Can you hear me all well in Rome and online? Yes? So good afternoon, everyone. It's really a pleasure to be here today. I wanted to start by just saying a few words about the SSF guidelines, because this is, of course, a very important moment. So the SSF guidelines offers important guidance for advancing the human rights of people within small-scale fisheries, in the small-scale fisheries sector, and to preserve the ecological basis of their food production systems. I think we are all very familiar with the SSF guidelines. What I would like to focus on today is though that although the guidelines are termed voluntary, the SSF guidelines also state that the guidelines are based on international human rights standards in its Article 33.1, and also that implementation of the guidelines should be consistent with obligations under national and international law. So in my presentation, I will, with the time I have available, show the links between, some of the links between relevant human rights standards and issues faced by small-scale fishers. This will not be an exhaustive overview, of course, but I hope that in the presentation I can underline the relevance of many of these standards and motivate all of us to use them more in our work, and also to exemplify how human rights standards are specifically linked to the SSF guidelines through the use of a tool that the Danish Institute has developed, the Human Rights Guide to Fisheries. So maybe just before I move on to my first slide, why should we draw on human rights standards? Well, states have a legal obligation and duty to respect, protect, and fulfill human rights of all. These are therefore binding obligations. Private actors and businesses as well have human rights responsibilities to respect the human rights and their fishers and their communities, as reflected in the UN Guiding Principles on Human Rights in Business. And of course, with these binding obligations, fishers and communities can actually use these standards to seek remedy for abuses and violations, and to, in general, uphold their rights. So that's why I'd like to sort of focus on what these international standards say and how they're linked. So maybe to the first slide. The first slide, please. The next slide. Yes. So yes, that slide. So here on this slide, you can see, and I know it's very small, I hope it can be seen, you can see how some of the issues that small-scale fishers face are both linked to specific human rights and to specific treaties and conventions. And as I said before, this is of course not exhaustive, and I know that things have been excluded, but I hope you can see, for example, how, for example, issues faced by fishers and their communities related to declining incomes due to reductions in fishing stocks, and the way that it affects small-scale fishers and their ability to cover their basic needs, and how declines in the availability of fish for consumption affecting the availability of food has an impact actually on their right to an adequate standard of living and right to food. Also how the lack of recognition of the right of small-scale fisher folks and indigenous fishing peoples to marine territories, marine resources and coastal lands are also linked to human rights related to land, territories and natural resources. How the poor contractual conditions that small-scale fishers often face with no formal work contracts, no clear agreements regarding working hours, limited rest, limited insurance in case of accidents or death is related to a binding right to work and to just and favorable conditions of work. How lack of access to social protection, despite the fact that small-scale fishers and their communities are confronted with a wide range of risks and vulnerabilities affect small-scale fishers and are linked to their right to social protection. The lack of recognition of cultural rights. The Human Rights Committee has been very clear that traditional activities such as fishing is to be protected as manifestations of culture, particularly in the context of the protection of ethnic, religious, and linguistic minorities. So in short, many issues that we hear of, that we document, that we see in our studies are related to these binding human rights standards and the related treaties. And I just want to highlight 4 issues when we look at this overview. One is that many of the issues faced by small-scale fishers are covered in the International Covenant on Economic, Social, and Cultural, not only, but many are. And this is a treaty that member states have ratified, with quite a large number of states have ratified this treaty. So these are legally binding obligations in most countries. I want to emphasize, as this document shows, or this slide, the interrelatedness of rights. As you can see, the issues span both economic, social, and cultural rights, but certainly also civil and political rights, and also cover issues covered in treaties that are focused on specific groups, like on CEDAW for women's rights, but also we can also have raised the Convention on the Rights of the Child and issues of child labor. They cover collective rights, particularly with regarding to indigenous peoples and their rights to land and territories, but also individual rights, and also rights contained as I mentioned before, in treaties that are more of general nature, so civil, the covenants on civil and political rights, but also those on the rights of specific groups. So the next slide, please. So what I will turn to now is an overview of what our human rights guide showed when we did a mapping of how the various SSF guidelines and the articles there are linked to human rights. As you can see, our mapping showed a large number of human rights are linked to the SSF guidelines. So you can see, but the size of it shows the frequency with which it appeared. So you can see the right to adequate standard of living really emphasized as being very directly linked to many of the SSF, the articles in the guidelines, cultural rights, rights to land, territories, and natural resources. So many of the rights that I have also just presented. So next slide, please. So in this slide, I wanted to show a very particular excerpt from our human rights guide, and there are many, it's quite extensive, and I should say it's not only linked to SSF guidelines, but other fishery instruments, but here I'm focusing on the SSF guidelines for today. So as you can see, we show very concrete examples of links between the problems related, or the principle and guidelines around not being arbitrarily evicted, and the need for respecting tenure rights being very much directly linked to specific international human rights standards, in this case, the International Covenant on Economic, Social, and Cultural Rights, but it is also linked to many other, and I haven't shown them all because the slide is already shows a small text. I couldn't put them all, but this is just a taste of, you know, how actually these guidelines have a underlying legal basis in these international human rights standards. And then I just want to close by turning a little bit to the role of national human rights institutions. So I am from the Danish Institute for Human Rights, which is a national human rights institution. And national human rights institutions, where they exist, have legal mandates established in national law to promote and protect human rights in their country, also in relation to the rights and the violations affecting small-scale fishers. So I just want to give an overview of some of the key functions, and of course this depends on the national context. The next slide, please. This depends on the national context. But for example, national human rights institutes have a monitoring and reporting mandate. So for example, they can undertake research and investigation, as some have already done, on the human rights of small-scale fishers in their national context. They also have a mandate to provide advice to governments, so they can provide advice to states on whether fishery policies and programs and agreements are in keeping with their binding international human rights obligations. They can receive, investigate, and respond to human rights complaints, those NHRIs that have a complaint management system. So they can accept and investigate and attempt to resolve complaints of human rights violations from small-scale fishers as well, and some are already doing this. They can cooperate at the national level with key partners, so they can cooperate with institutions, with small-scale fishers, with small-scale fisher organizations to advocate for reforms of laws and policies and practices. They can engage with national and international and regional human rights systems, so bringing the human rights violations and issues faced by small-scale fishers to international regional bodies, which some are also doing, and they can deliver human rights education programs. So this is just both a call also to NHRIs, to ourselves, to maybe look at this issue more in depth, but also a call to explore opportunities for cooperation at national level between NHRIs and small-scale fishers and fisher organizations. And I think I will thank you and stop here.
Many thanks, Karen.
Thank you so much. And it's been really a pleasure in the past year, 2022, the International Year of Artisanal Fisheries and Aquaculture, to explore with colleagues at FAO and also at the UN Office of the High Commissioner for Human Rights, how we can, in fact, deepen both the collaboration that Margaret mentioned about those bodies involved in sustainable fisheries and those involved in human rights, but also bring some of the research from the ground that many colleagues at the One Ocean Hub from South Africa, from Ghana and Namibia who are online, have been really from a social small-scale fishers and in what ways their human rights are affected. And what we realized was an important message to convey to governments and to those involved in human rights work and fisheries work is really reflecting on the full extent of the human rights-based approach. All those rights that Carol has illustrated to us and all the multiple international human rights treaties that are relevant, it's really important to understand how each right and the protection of each right plays a role also in the protection of the other human rights at stake for small-scale fishers. And there's a connection between their protecting their economic and social cultural rights and how this allows them and members of those communities, such as, say, women, for instance, to have civil and exercise their civil and political rights. And of course, how the recognition of a human right to a healthy environment also help us to understand the interlinks between all these human rights and their dependence on a healthy ocean. And maybe if we do one more click, Senia, I think what we've discovered time and again through our work on the ground in the One Ocean Hub is the importance of cultural rights in particular, how those rights usually tend to be less understood and have multiple layers that have to do with how small-scale fishers are misunderstood, are marginalized, maybe have been historically discriminated. And that has to do with understanding the uniqueness of their knowledge systems about fisheries and the ocean, but also the customary laws and customary rights and governance systems through which they self-regulate their own interactions with fisheries, their cultural heritage, tangible and intangible, all the spiritual, religious, and other connections to the ocean that we might not understand or be even aware of because of the different culture from which we're coming from. And ultimately also the importance of arts practices as a place in which we can learn and actually come to appreciate all those connections that small-scale fishers have in unique viewpoints on the ocean and sustainable fisheries, and also as a place where maybe we can co-govern sustainable fisheries in that space of learning and mutual respect. And I think one of the key elements here is that really going a bit beyond what the text of SDG 14 says around looking at access to resources and markets. That is essential, but in and of itself is not sufficient to necessarily ensure that coherent protection of all human rights. And in fact, each and every human right can help making the access to resources and markets realistic, feasible, secure, and meaningful and culturally appropriate for small-scale fishers. So if we go on to the next slide, I think the importance for FAO and the High Commissioner for Human Rights and the Hub to bring together our insights in a policy brief, which we published at the end of last year, to really mark I think a step forward in our path of collaboration and deepening of understanding of the human rights to the human rights-based approach in the context of the small-scale fisheries guidelines is really understanding that while it may be overwhelming for government officers and others involved in the fisheries sector to engage with human rights, all those treaties obligations, all those complex dimensions and fascinating dimensions of the interactions between small-scale fishers and their environment, it is important to engage with the human rights-based approach as a programmatic tool, something that helps us to think through all the implications when we take certain choices in the context of the management of fisheries more broadly, in the management of other marine or terrestrial resources, which may have impact on small-scale fisheries, and really engaging with human rights as a tool to better understand what is at stake, for whom, who is going to be impacted and in what ways. And also what are the opportunities and the need to recognize the role that small-scale fishers plays, not only in protection of their own rights, but in fact, in protection of all of us, everyone's human right to a healthy environment, which includes a healthy ocean and healthy fisheries, and in fact, on which everyone's right to food, water, and health very much depends. And so there's a message there which we're hoping to further engage and explore about how, by bringing together the communities of human rights experts, those of fisheries experts and environmental experts, we can connect more our areas of expertise and knowledge to really engage with human rights in that preventive fashion, in that planning fashion, and also building each other's capacity to really making sure that each and every human right of small-scale fishers is understood and protected, and help us to basically govern in a more consistent, coherent, and meaningful way the resources and any potential negative impact on small-scale fishers. Thank you, Elaine.
Thank you very much, Lisa. And over to Anna, please. Thank you. Good afternoon, everyone. It's a pleasure to be here with all of you today. So, as we consider many international instruments that are relevant to the small-scale fisheries sector, which has been explained by Carol, and the importance of implementing these instruments coherently at the national level, the question arises of how we can effectively do this. So, in response to this question, FAO has developed several tools and guidance documents to support the implementation of the small-scale fisheries guidelines through national policy and legal instruments. So we understand that we have been talking this morning about the need to ensure that human rights of fishers, fish workers, and their communities are respected, promoted, and protected, while also clearly defining their duties without putting an unfair burden on them. So to achieve this is fundamental that policies and laws are aligned with a human rights-based approach, but also they reflect the international human rights framework. If you can go to the next slide, please. So the first tool that we have here is the SSF policy and legal diagnostic tool. And this tool provides a methodology for identifying national policies and legal instruments that are relevant to small-scale fisheries and assessing their alignment with the SSF guidelines. It provides guidance
on identifying a country's status with respect to legally binding and non-binding instruments. So it provides a list of the relevant binding and non-binding instruments, and identifies for countries to identify which national policies, and legislation incorporates such instruments at the national level. So based on these assessments, users are able to identify the strengths and gaps in the national policy and legal frameworks with respect to the small-scale fisheries guidelines implementation. The other guide that we have here is the legislating for sustainable small-scale fisheries. We call it the legislative guide. And this guide provides guidance on legal aspects that should be taken into account when drafting legislation for the small-scale fisheries sector, and how to structure and align the law with the human rights based approach. So following the human rights this morning, public participation and meaningful consultation is crucial as to ensure that all stakeholders' voices are heard and duly considered, including those who are traditionally marginalized and underrepresented. So public participation during the legislative process not only increases the legitimacy of the new law, but also creates a sense of ownership and leads to implementation. And I think here, at some point, it will be interesting to review this guide and apply some of the concepts we learned this morning, to apply different ways of thinking of how this public participation and consultation can be done also in the legislative process. So to support the identification, if you can go to the next slide, to support the identification of the laws and policies that are relevant for the small-scale fisheries sector, we have created a database called SSLX, and you have all this flyer where you have a QR code. You can go straight to the website, to the database. And this database is a user-friendly platform with information on national legal and policy instruments relevant to small-scale fisheries. So this platform includes country profiles, where you can find information on international and regional commitments, constitutional provisions, what are the institutional arrangements, what are the definitions of small-scale fisheries, if there is one, and of related terms in the country, and an analysis of legislation and policies following the structure of the SSF guidelines. So our goal here is to showcase how states have already incorporated elements of the small-scale fisheries guidelines in their national legal frameworks, including human rights principles related to civil and political rights, the right to food, culture, healthy environment, and so on and so forth. For example, we're starting with the analysis of the Constitution. And lastly, we have developed an e-learning with the One Ocean Hub that is called Legal and Policy Considerations for Small-Scale Fisheries, that explains how to use these different tools and guidance and analyzes key elements of national policy and legal frameworks from a human rights perspective. My colleagues are putting the links on the chat of all these tools and guidance. Finally, as you know, 2024 will mark the 10th anniversary of the Small-Scale Fisheries Guidelines, and this will be a great opportunity to highlight the critical issues that we are addressing today. And this will be a significant milestone, which will offer a valuable collective opportunity to reflect on our progress until now and to chart a path forward. Thank you all for your attention.
Yes, so we realized this is a bit of an awkward space with many participants online and a few here. And I know we started with quite a few, I think, quite dense pieces of information. So we would like to invite the colleagues online, as well as the colleagues in this room, to participate in interactive exercise. So we have what's called a Mentimeter. We have a question for you just to hear, get a sense of the temperature in the room about how do you feel about human rights, our small-scale fishers, and what do you think are the main challenges in protecting the human rights of small-scale fishers. So we have a link or a Menti code, so you have to go to the menti.com site, and if you use this code, you'll all be able to participate in a live survey. And we should be able to see results in real time, just to get a sense of your views, as we don't have time quite yet to open the room for debate, but we will get there pretty soon. So yes, if you can just invite you to get on the site and let us know what you think at this stage. It'd be interesting then to have a similar question towards the end of the event to see how our collective thinking has evolved after the other presentations. Yes, so I think we can show it now. We have a few answers already appearing. So we'll start to see a few views from across all the community of practice that's come together in this webinar about key challenges in the protection of small-scale fishers' human rights. And I think what we've learned throughout the year is how many of these challenges are shared across regions and countries from the global north and the global south, and the importance of sharing what we're learning about tackling these challenges and finding helpful strategies to bring people at the same table and address them. But many issues, from very specific ones about defining small-scale fishers, national legislation, recognizing tenure, political will and resources within governments, those aspects related to culture and customary rights, and also very real conditions around power asymmetries and perceptions of what human rights are for and what they demand from different duty bearers and other actors. So we'll keep this going. So if you want to keep going there, I think this is a really important source of understanding for us about the work that's needed going forward. But we just wanted to have that sense of what is on people's mind as we move towards the second set of presentations. And we're very privileged to have colleagues from Geneva whose presentation I think will help us think through these concerns that you have shared with us.
Thank you. So yeah, we're delighted to now welcome our two panelists from the Office of the High Commissioner for Human Rights. Jaime Fuentes Maria is a human rights officer focused on economic, social and cultural rights. Jaime will speak first, and then we'll go to Jamshid Gaziev, who's also a human rights officer working on the mandate of the right to food. So we move now to engaging with the international human rights mechanisms. Jaime, the floor is yours.
Thank you very much, and thank you for inviting me to this really wonderful training. I'm very, very honored to be with you. And so I am a human rights officer working in the economic, social, and cultural rights section. And this section is based in Geneva, and it covers the thematic work on the right to food. But as you have mentioned, human rights are indivisible, and so we cover all other economic, social, and cultural rights, and with a link also to civil and political rights. We serve as the substantive secretariat to the UN human rights bodies and mechanisms. And that is a different part of the office, but we work closely with our colleagues to make sure that we are supporting the development of international norms and standards and advancing human rights protection in all the work that we do. In our work, civil society organizations and national human rights institutions are really crucial partners. They are partners as well for all the treaty bodies. And so I would like to explore with you today how to engage better with these mechanisms, what they are, and what you as national human rights institutions and members of civil society organizations can do to better, to enhance the work of these committees. Then I'd like to pass over the floor to Jamshed, who works with another arm of the human rights mechanisms that we have, and it's the special procedures of the Human Rights Council, including the special rapporteur on the right to adequate food. So let me start. I will focus on what the treaty bodies are. I am not sure if everyone has engaged with the treaty bodies before, so I'd just like to very quickly give you an overview. The treaty bodies, or the committees, as they're often called, the human rights committees, they are groups of independent experts, and they have a mandate to monitor how countries that have ratified one of the 9 human rights conventions are actually implementing those conventions and putting them into practice on the ground. So when countries ratify a treaty, they have the obligation to, of course, implement the treaty, and another obligation to report how they are implementing the treaty. So all the legal, programmatic, policy, and other necessary measures to make sure that the treaty comes alive. And they carry out their main mandate of monitoring by examining the reports that they receive from countries periodically. So each country has to give an initial report, and then every 2 to 4 years, depending on the conditions of the treaty. The committees meet here in Geneva, often twice a year. And even though the rules of procedure and their guidelines are specific to each committee, in general, their work is the same. So they hold a dialogue with a country here, with a country delegation. And this dialogue is really to better understand the country situation and to help each country better implement the treaty provisions. Then they publish a document, and this document is called the Concluding Observations. And this contains the concerns that they have identified over the course of their examination of the report and the dialogue, and also some recommendations concerning the different human rights situations. Most committees also have a mandate to receive and examine complaints about alleged violations of human rights under the treaties. And some committees also have a mandate to conduct confidential investigations called inquiries, which would include a visit to the country. So how do they work? Well, when a country ratifies the Human Rights Treaty, so they have the implementing obligation and also the reporting obligation. Treaty bodies have to consider these reports, and to get a better picture of the country, they cannot only depend on one country report. They depend on all available information, which may come from the UN system. It may come from international NGOs, but a lot of it comes from NHRIs and from civil society organizations working in the country. And that is really where the contributions of your expertise, your local knowledge, your experiences, and your national monitoring is really crucial and valuable to the work of the committees. For the committees to have an accurate picture of what is going on in the country, they really count on the valuable information that civil society can provide. So based on this process, they will receive written submissions, but also they can meet in Geneva to have a side event or to have a bilateral briefing with representatives of NHRIs and civil society organizations. So I think for you, it's very important to check the websites of each of the committees. These websites are linked to the Office of the High Commissioner for Human Rights website, and there identify the countries that are coming up for dialogue with the committee for each session. As colleagues before me have said, the concluding observations are really a tool. They're a programmatic tool for countries to implement human rights and to know the priorities that they can follow in the next 2 to 4 years. And I saw from the Mentimeter that one of the obstacles or the challenges is that human rights are seen as very challenging to implement. So actually, the committees offer this roadmap in the form of a concluding observations that is really to be seen not as a challenge, but actually as a guardrail to implement the obligations of the states. So also for you as civil society, these concluding observations can be an advocacy tool. They can help focus all the efforts of different actors around one same goal until the next periodic report. So as I said, the periodicity will depend on each of the treaties, normally from 2 to 4 years. So in this reporting cycle, where state party reports and then the committee holds a dialogue, issues the concluding observations until the next periodic report, there are various opportunities for engagement. As I mentioned, one is to come up with your own alternative report. It can be based on the state party report, or it can be based on your own analysis of the treaty provisions, so article by article, or focusing only on the most challenging situations for the human rights of small-scale fishers, or for certain groups within small-scale fishers. Then there is also an opportunity for what is called a list of issues. A list of issues is a list of questions that the committee asks the states parties in writing in order to get additional information that is not clear from the state party report. And when the committees are drafting this list of questions or list of issues, you can also have an opportunity to submit proposed questions or to submit a short report highlighting why certain questions need to be addressed. You may also submit your own answers to the committee's list of issues to the states, so in the manner of an alternative report. And now more and more committees are moving towards a procedure called lists of issues prior to reporting. This is intended to facilitate the reporting obligations of the state, because as was mentioned before, there are many different ongoing initiatives. There are many different reporting obligations under the treaties. So in order to alleviate these reporting obligations and focus really on the implementation, some committees have decided that instead of waiting for a state party report, the committees will initiate a list of questions, and the answers to these questions will constitute the report. So here's another opportunity for civil society and civil society organizations and NHRIs to also come up with their own questions, and if you want, also to your own answers when the answers of the state are not complete or they require a bit of clarification. In addition to the reporting cycle that you can be involved in, many of the committees, as I said, may consider complaints or individual communications for alleged violations of rights, and you may be involved in submitting these complaints. You may also be involved in initiating an inquiry if you have monitored a situation and you have enough reliable information containing well-founded indicators of a serious, grave, or systematic violation of human rights under the treaty. And for example, I know for the Committee on the Rights of Persons with Disabilities, 2 out of the 3 inquiries or confidential investigations were initiated by information received from the national human rights institutions. So really, the role that you can play in these processes is really huge and very crucial. Another part of the work of the committees is the adoption of general comments. General comments are a substantive guidance for states and for other actors on how to implement certain provisions. The general comments go through a procedure that is consultative. So there are thematic discussions, there are open days of general discussion with all stakeholders. So in that regard, it is also really important to look at the website of the committees and see any upcoming opportunities for general comments that may be of interest. So here I would like to highlight the upcoming general comment of the Committee on Economic, Social and Cultural Rights on Sustainable Development and Economic, Social and Cultural Rights. There is no draft yet, but there will be a first draft that will be published in the committee website. And there you have an opportunity for written submissions and for engaging in the process of developing this very important general comment. The Committee on the Rights of the Child is also working on another very relevant general comment. However, the process for written submission has finished already. So these are some of the ways that you can engage directly with the treaty bodies. But in addition to this, you can engage with the state authorities to work with the treaty bodies. One way is promoting the ratification of a treaty or promoting the ratification of an optional protocol. The optional protocol to a treaty in some cases allows for the treaties to have this mandate of receiving complaints and issuing their decisions, or they have additional rights, for example, in the optional protocols prohibiting the sale of the child or children in conflict of the Committee on the Rights of the Child. Then you can also continue your monitoring at the national level. So you are like the national equivalent of these international monitoring bodies, and also work together with states parties. There are many countries where civil society organizations also work together with states parties in the preparation of states parties report. In some countries, state also facilitates a consultation and request feedback on their own state party report. So this is also a very good opportunity for collaboration with states. Depending on the rules of procedure of each of the treaty bodies, national human rights institutions that are accredited status A may also take part in the official dialogue with committees, either as part of a confidential briefing before the state party dialogue, or within the space of the state party dialogue as an independent body in charge of monitoring at the national level. Then, as I mentioned, as was mentioned before, there is a role for you in monitoring and compiling information for early warning and urgent procedures of the committees. So the Committee on Elimination of Racial Discrimination has developed a procedure for early warning. We see that escalating social conflict, social protest can be an early warning of larger crisis, and it is crucial to really act at this early stage in order to prevent further escalation. And so in this role, you can also provide information to the treaty bodies, especially to the Committee on Elimination of Racial Discrimination, as well as to the Office of the High Commissioner for Human Rights. This link between peace, prevention, and human rights is really, really crucial. As was mentioned also by previous speakers, all human rights are universal, interdependent, indivisible, and interrelated. And this slide that Carol presented on the SSF guidelines and the rights that underpin the guidelines was really useful to exemplify this fact. And also the human rights situation of small-scale fishers, fish workers and their communities has been considered by a variety of human rights committees. So this is really to exemplify that all rights are interdependent. So we have the Committee on the Elimination of Racial Discrimination, but also the Committee on Economic, Social, Cultural Rights, the Committee on Elimination of Discrimination Against Women, the Committee on the Rights of the Child, the Human Rights Committee. They all have raised the issue of the human rights situation of small-scale fishers. Here, I really encourage you to engage with the treaty bodies. I can tell you from working with the treaty bodies that many of the issues that have been raised in recent concluding observations or list of issues are there thanks to the work of civil society and national human rights institutions that bring these issues to the attention of the committees. However, the committees receive a wealth of information, voluminous information. So I also encourage you to be focused, to be concrete on your concerns and your recommendations to the committee, to really bring forward why the issues are important, who they are affecting, the rights holders that are being affected, and to really bring the attention to the committees within the reporting cycle. I really think the reporting cycle of all the committees is one of the best opportunities. So really pay attention to when your state is coming up for review, and then link your engagement with the committees to this reporting cycle. Know about the general comments, know about the days of general discussion and the opportunities, and learn about the individual complaints and the inquiries mechanisms. For that, the secretariat of each of the committees, the secretariat being colleagues here in Geneva in the Office of the High Commissioner for Human Rights, really are at your service. They are there also to explain how to engage with each of the committees, to explain the different procedures that each committee has. And it really is in the interest of the committees to engage more with civil society and with you. So I was looking at some of the calendars of the states parties coming for review For example, for the Committee on Elimination of Racial Discrimination, this year, later this year, we will have South Africa, we will have Namibia, Senegal. In April, we will have Niger. For CESC, the Committee on Elimination of, the Committee on Economic, Social and Cultural Rights, we will have Chad, Mauritania. For the Committee on the Rights of the Child, as I mentioned, we will have the general comment on children's rights and the environment with a special focus on climate change. So these are just some of the ways of engaging, but I really wish to underscore how crucial your participation is, how crucial your role is for the work of the Office of the High Commissioner for Human Rights and also for the work of all of the committees. And I am also at your disposal for any questions and I look forward to further engaging with you. Thank you.
Many thanks for that overview and also for highlighting the impact that it can have to engage with the mechanisms. So thank you very much, Rumi. Jamshid, over to you.
Hi, Elaine. Can you hear me well? All right. I don't hear you, but I think you said yes. So I've got a presentation, so I'll share my screen if you don't mind. I hope it works well. Do let me know if it doesn't. Can you see it? Oh. Are you on mute, Elaine? You're on mute.
Yes, we can see it.
Okay.
Good.
All right. Thank you, Tula. All right. I can't see the expressions on the faces of colleagues, but I really rely on our moderator to let me know if there are somebody who has a question, immediate question or reaction. So I'm really happy to be stopped and to address any questions, burning questions immediately during the discussions. So I have, from what I understand, I have two slots. The first one is to really discuss about how to engage with UN special procedures, special rapporteurs. And then after the dialogue, we'll have a bigger and more focused discussion on a country visit and the communications in terms of how we could cooperate and to zoom in and have some practical interactions on those possible cooperations and interactions. So my name is Jamshid Gaziev. I work at OHCHR in Geneva. Like Harumi has mentioned, I work in special procedures, supporting the mandate of the Special Rapporteur on the right to food. I've been working in I've worked in OHCHR for 12 years. I've worked with different rapporteurs in different thematic areas. So from environment to health, from health to rule of law, to human rights defenders and food. So I've worked in different areas of human rights, and I can really attest that human rights are indivisible and interdependent. So we can't really separate them. So I'll try to approach my presentation from that angle to address three questions. I think I have 15 minutes, so I'll try to be punctual so we can have enough time for dialogue. So the first issue we need to discuss, who are special procedures? Second is what they do. And maybe I'll try to zoom in quickly on the topic of fisheries and the right to food mandate. So specifically a look at what has been done previously by the mandate and some briefly plans for future. So, all right, I can't see my own screen, but special procedures, let me see, how can I remove that? Okay, maybe I can do a different view. I'm just trying to view it differently, maybe. Hide video panel, voila. Okay, so special procedures are established by Human Rights Council. So it's when we talk about special rapporteurs, they really are accountable to the Human Rights Council, to member states. And they have a very specific mandate, which is to either address a country situation or to address a thematic issue, but with a broader geographic coverage, which is global coverage. You will have different names for those special procedures. You've heard special rapporteurs. There are also working groups, which consist of groups of experts, one expert per each region. For example, a working group on arbitrary detention, a working group on business and human rights, and the working group on discrimination against women in law and practice, just to name a few. And those are working in the same way as special rapporteurs or independent experts. It's just a different names given to these experts. They're appointed for their expertise in specific thematic area or expertise on a specific, focusing on a specific country. They serve voluntarily in their personal capacity, and that's very important to understand. They are not UN experts. They are experts appointed by the UN Human Rights Council that gives them independence from the UN as an institution, and they are accountable directly to the Human Rights Council. And that means that they act in their personal capacity based on the international law, international human rights law, and based on basically inputs they receive from governments, from civil society, from communities, from national human rights institutions. And that's why you will quite often see special rapporteurs talk and engage in dialogue with all parts of society, with all stakeholders, and keeping an open mind. So next slide. They are appointed competitively. So that means anybody can nominate experts during the nomination process, and they're selected by a group of member states representatives. And finally, it's the president of the Human Rights Council that pronounces or declares the appointment of the special rapporteur. Their tenure depends. For example, country rapporteurs, they have yearly tenure. They have to be renewed by Human Rights Council resolution. Thematic ones are usually 3 years plus 3 years, and it's normally approved. The second renewal is approved in most of the cases. It's rare that a rapporteur would not be approved, or would not be, his mandate or her mandate would not be renewed. Their work are usually guided by two things. The first one is the Human Rights Council resolution that appoints that mandate. So when we talk about any specific rapporteur, we really need to open up the resolution that establishes that mandate and check what that rapporteur, that mandate holder, is supposed to do. And the second thing is the code of conduct. It's a code of conduct that was established by the Human Rights Council to make sure that there is one level playing field, and there are rules that govern the behavior and the work of special procedures. Given so much of independence and impartiality at stake, there had to be some rules devised to make sure that governments, other stakeholders, civil society, business, they have the same trust and confidence in these special rapporteurs. And that's why you have a special rapporteur's code of conduct, which they are supposed to follow in the working methods. In terms of statistics, you'll be surprised to see there are quite a lot of thematic mandates. There are currently 45 thematic mandates. And that ranges from the right to food, right to healthy and safe environment, right to health, education, to torture mandate holder, to right to water, to enforced experience working group, arbitrary detention, as I mentioned, summer execution. So you've got whatever human rights violation you may have in mind or you may encounter. Normally there will be a mandate holder that can deal with that situation. And there are also 14 country mandates, and I've given the references, the hyperlinks, that in case if you want to consult and to learn more about specific rapporteurs and specific country mandates. In terms of support they get, since they're voluntary and they represent themselves, they don't represent the countries that they come from, they don't represent institution where they work, where they actually do their job. They are supported by OHCHR, which is my branch. And they're also given funds dedicated for the work and the logistical support to carry out the work. So that's what basically makes the work independent. So they don't rely on extra budgetary funds only. So there's a core budget that they can actually use in their activities. So what do they do? I think I'll start with global monitoring, the first 3 points, and the country visits communications. We can do at a later stage where we can zoom in into those more specifically. In terms of global monitoring and advocacy, as I mentioned, when we talk about thematic mandates, rapporteurs can deal, they're expected to monitor the situation of that thematic area globally. It is a very big call because capacity is quite limited. So you've got one rapporteur or one expert, and then you have one staff member, or half staff member, or 1.5. So it depends, but it's not a big team. So there has to be some way of selecting, prioritizing the issues, but at the same time, that is a freedom to maneuver that where rapporteurs and experts can decide where to focus more, and they can coordinate among themselves, where one rapporteur would focus on one situation in the country and the other in another, given that we, as was mentioned earlier by colleagues from FAO, interdependency of human rights, when we talk about fisheries, you could mention several rapporteurs that could be relevant to deal with the situation of the fisheries. We are talking about advocacy. We have a number of tools already available. Harumi mentioned about treaty bodies, and Carol mentioned about the connection between fisheries and the international human rights instruments. So we've got a lot of policies and international human rights law backing up and supporting our human rights. So what these rapporteurs do, they try to really advocate specifically, zooming in specific situations, specific contexts, or specific events or processes. For example, 2 years ago, the special rapporteur on the right to food we were as a team focused on dealing with the Food System Summit. And that was a global sort of process to focusing on food system transformations that was happening during COVID-19. And there were a number of concerns raised by civil society and communities that the special rapporteur tried to sort of redirect, rechannel, and emphasize and make sure that the Food System Summit organizers could actually take into account those concerns and try to make that event a lot more inclusive and a lot more consultative. There's just one example. There are many more examples that you can see on our website where specific examples are shown where rapporteurs actually focus on making the changes on the ground. So we are not really talking only theoretical, only policy, only laws, but we're also talking about how to apply them to improve the situation. So there you have one of the most, I would say, probable and useful allies, special procedures, because they have the same interests as national human rights institutions, as civil society organizations, as academia, to make better changes for the society. Now, we also talk about quiet diplomacy. Most often you may not hear what special rapporteurs do, but they do engage quietly with ambassadors, they do engage quietly with different parts of the UN. Just for example, from the perspective of the right to food rapporteur, Michael engages quite significant, spends a significant time, his capacity and time on engaging with delegations at CFS, at the Food Security Committee, but also to engage with FAO, Rome-based agencies, but in any other organizations and networks that sometimes need either more convincing, or they need a bit of more support, or sometimes actually we need their help to make sure that the messages are heard and the messages are really conveyed to the authorities in the right way, and to encourage that change in behavior. We are talking about issue public statements that probably you may have seen quite a lot, and I do encourage you to check the media section of our office, because you will see that from special procedures, you nearly get several statements a week, either on country situations, when a special rapporteur visits a certain country, or a rapporteur speaks about the alleged violations, or there is actually some international, for example, Water Day or international food security. It really depends on the situation, but they all take advantage of an opportunity to use the statements and social media to push the envelope further. Now, in terms of visits that are other than country official visits, there are other ways that you can involve and engage with special procedures. And a number of, many of national human rights institutions or civil society organizations, they work in networks And quite often we've seen that regional consultations are organized across Africa or Asia to focus either on emerging issues or focus on cross-country situations, or really aiming for a stronger solidarity and cooperation. And those are good opportunities to engage special procedures, usually to bring an independent international UN expert to bring in that international perspective and international expertise and add a bit of more additional voice and support for that activity. The special procedures and the mandate holders, they also support a lot of workshops and trainings on thematic issues. For example, the latest one, you may have attended the webinar organized by One Ocean Hub and the Danish Institute for Human Rights on the same topic. The special rapporteur, Michael Fahri, was there to support it. So this is quite often, and it is an opportunity both for the rapporteurs to really reinforce those activities and to help those community members or civil society members or governments to really train, build capacity, or raise awareness. So that those are the opportunities if the capacity allows, of course, and quite a lot of times they send video messages or statements as well. So there are practical ways of identifying ways that special procedures or specific rapporteur or specific expert can be of help in specific situations. We also have had a number of situations in countries that are sensitive, that are may not be that willing to have a formal country visit. And we saw, with the help of National Human Rights Institution, for example, or with a network of civil society organizations, they organized seminars or conference on a theme, on a topic that is of their interest. And that was an opportunity for special rapporteur to come, or working group member to come to this country and really speak about the international angle, speak about international experiences, international law, because that's not a still official country visit. But it's an opportunity to really raise awareness and informally meet government officials without making formal recommendations. So in terms of thematic reports, and that's where moving to the part that may be of interest to you, all rapporteurs and all special procedures, they present to the Human Rights Council once a year. Quite a lot of them, majority of them, they also present a report to the General Assembly. For example, the special rapporteur on the right to food does both. It depends on which session, be it in March, June, or September of the Human Rights Council, but they all come to Human Rights Council and present the reports, and the General Assembly in October usually. And they choose the topics depending on the situation on the ground and the inputs they receive from civil society, from NHRIs, and from governments. And usually these are to address protection gaps, or to address emerging issues, or to really reinforce the need for a new policy, maybe instrument, or to identify opportunities for improvement. And those reports, they serve as an advocacy tool or as a legal tool, in fact, to really, sometimes when there is no consensus among member states, it falls on the human rights mechanisms to come up with initiatives and to address that gap in international human rights law. I'll go now to for example, the reports by the special rapporteur on the right to food, by the mandate of the right to food, to give you an understanding, for example, to what extent the mandate has been involved on the issues of the fisheries. And you can see back in 2004 by Jan Ziegler, many of you may know him. He was one of the prominent mandate holders. He actually had a whole chapter in his report to the General Assembly, talking about the linkages between fisheries and the right to food. And at the time, he was talking about that issue as the emerging concern, is emerging issue. And back then, he was already advocating for the right to food approach, and he was outlining already responsibility of states. Responsibility to protect, responsibility to respect, and responsibility to fulfill. I mean, we can look into those responsibilities more clearly, but those are really the language that normally special rapporteurs or UN human rights bodies would use when it comes to economic, social, cultural rights. Oh, I moved too fast. 2012, Olivier de Schutter, the next special rapporteur, he had he focused his report again on the fisheries, but from the perspective of the fisheries sector contribution to the realization of the right to food. And at the same time, he was also highlighting the vulnerabilities of the fishing communities to food insecurity themselves. And he outlined some recommended actions to guide global and national level policies. And that actually report was just at the time when FAO committee was reviewing the small-scale fisheries guidelines. So that was a very much strategic reason why the special rapporteur at the time, Olivier, decided to focus his report on the fisheries. And that contributed to the discussion on bringing more right to food also to the small-scale fisheries guidelines. In 2019, Hilal Elver, she decided to focus on the role of the fishery workers and food security and nutrition. And there, she really tried to identify challenges and barriers that the workers themselves face in accessing food and adequate food and exercising that right to food. And that was a protection gap. Up to now, we're still receiving a lot of concerns about fishery workers and how better the rights could be protected in the context of the work, in the context of the livelihoods. And that was one way that the previous rapporteur tried to address the issue. Finally, in 2023, Michael Fahri, the current rapporteur, decided that we will focus on the report for the 2024 Human Rights Council. We will focus it on the fisheries again. The difference this time, we've got new emerging issues. We've got the International Year that has been celebrated up until this week. And we're hearing a lot of inputs, a lot of feedback from communities, civil society organizations, that the issue is still painfully urgent. And for that reason, there will be a number of things that the team and the rapporteur will do. We'll be seeking inputs. We'll be doing call for inputs from member states, from civil society organizations. There will be some consultations. There will be bilateral meetings. They've already started. They've been already launched. And there will be a number of activities that we as a team and the rapporteurs agreed to focus and prioritize more activities focusing on the fisheries this year, such as this one, such as the webinars that I mentioned earlier, such as the future ones that may come along. And finally, communications, that's the topic of my next presentation, that we will encourage to submit more communications that would give us about more understanding about specific cases, allegations or violations on the ground. So I think I'm on time, and I'm just giving you more instruments here about the website, general website on the special procedures, facts and figures that are quite interesting to give you an understanding the overall work and the scope of special procedures. You have a directory with the photos, emails, and the names, so you can have it all there, and a brief video about special procedures by former and current special rapporteurs. I hope you will enjoy it, and I will stop sharing it now. Over to you, Elaine.
Wonderful. Many thanks indeed for taking us through all of that, and also for making connections back to small-scale fisheries again. So we have a little bit of time for discussion. We will keep an eye on the Q&A from our online participants. Also, if you're in the room, please make yourself known, and if I can ask you to introduce yourself before you contribute if you wish. If we have taken comments from the room, we can pass around the microphone. So we'll just please be patient with us.
Just check was. Okay, I'm going to ask
There's one question in the chat, Jamshid, that perhaps you could take from Manuela. What are the emerging issues that are being considered for the 2024 report? So that's specifically a question in relation to the work of the Special Rapporteur on the right to food. Maybe we can start with that, And there's also another question in the chat there, for those in the room who can't see, how to improve fisheries labour rights for DWF fishing fleets. Related to the mechanisms for harbour as well. So one more question, please.
Yeah, thank you very much. I hope you can hear me. I have a question on the special procedures. It's a little bit like in FVO, we have these voluntary guidelines and instruments, and I want to know with the special procedures, how do you see the impact, for example, of these reports? You mentioned all the reports that have been done on fisheries. I wasn't aware of the 2004 one, by the way, so thanks for that. But I understand that now in 2024 will be the fourth report focusing on fisheries and the right to food. What is the uptake of that? Who's kind of taking these reports forward, and who's following up on the recommendations, and what can we do to advance that collectively in the UN system, but also with the other stakeholders?
Okay, so I'll invite Jamshid to respond, and potentially everybody feel free to come in if you wish. Thank you.
Thanks. I mean, the last question was, I heard it really well. I think maybe I would just recommend using the same mic, because it's just, in terms of the quality, it seems to be much better. Elaine, I don't want to fault you, but it's just, I think it's the technical issue. So I'm sorry if I miss out something. So I'll start with the last question maybe, and it's linked to the question that on the chat about the report. We are working on the report. The work on the report has just started. So there is plenty of opportunities to really contribute to the shaping of concerns, issues, the scope and examples, that information and input that you may wish to provide as an individual, as an organization, or as a collective network body or an HRI. The reason I'm saying this is one of the reasons that I agreed to speak now is really to sensitize, because what we want to achieve, we want to make sure that the report is based on the issues that are relevant to the ground, that are really reflecting the reality, the human rights situation of the fisheries communities and the fisheries sector. We want to also understand to what extent the issues are different, maybe across different regions and countries and situations within. We want to understand how different groups may be vulnerable to different risks and different situations. So in a sense, what we're going through is really listening exercise. We've been attending a number of these events, such as this one, where we try to learn. So for example, even though it's a training that is supposed to be for you, I'm being trained at the same time. So I'm really here to learn from you, because what we want this report to be relevant both for human rights communities or human rights organizations in Geneva and elsewhere, but also for the fishing communities. It has also to be relevant to governments that would need to really pay attention and try to implement it. So we will need to listen to all different stakeholders from different areas of work to make sure that the report is balanced. So there will be opportunities. Normally we do call for inputs, public call for inputs. So we will come back and circulate to participants in due time. We will organize consultations, we'll organize bilaterals. And when there are opportunities to have more meetings, we will normally be very opportunistic in a good way and jump in and say we are interested to at least to attend and to listen. So really, the moment is now. And in terms of the uptake, I think the question in terms of the uptake of this report and the voluntary guidelines, it really depends. The reason why we want to really sensitize and raise awareness among different stakeholders, civil society and government officials about the report is to make sure that they not only contribute, but they will be the ones that will try to push through for follow-up and implementation. So there, in terms of policy and law, we see the voluntary guidelines as a excellent tool, as a really useful policy tool that we can use. And the database that you shared and all those sort of achievements that FAO has made in terms of implementing it on the ground, we'll try to take advantage of that and show in terms of carrot and stick approach, saying, look, there are some things that have been done anyway by your governments or by your authorities. So what we want to do is just to make sure that it's done through a human rights-based approach. So with the understanding that what is being done is not only good for the fish, not only good for the fishers, but in the communities, but is also good for the country and for human rights. And there, sometimes we may need to use the stick, and that's where special rapporteurs are good at, or that's their sort of niche, it seems to be, where they can actually criticize any shortcomings and lack of progress, or concerns maybe that may be identified during this inputs, the concerns about how, for example, the fishing communities are treated, maybe how their rights are being undermined, or how specific developments, maybe in trade or developments in global developments, like foreign debt, or in other situations, may be impacting certain communities or certain situations. So the uptake will be really the second phase, but from the beginning, when we already devise a report, when the rapporteur is taking all those ideas and suggestions, he will be really asking, what do you want, what is the concern, and what do you want to change, and what would be the change that you want to see on the ground? Because that's a collective challenge for everyone. We at least in human rights, we're quite good at criticizing and identifying the problems and challenges, but then when we have to find concrete solutions, this is a lot harder because we need to engage a large proportion of stakeholders and engage more sort of sectors of the society and convince more individuals and organizations. So that I don't know if I've answered all questions. Lane, I don't hear you.
Yeah, we're here. There's a question about Harumi might point to a particular mechanism that might be valuable there. Harumi, if you're there, if you would like to come into the question in the Q&A regarding labour rights.
Thank you. Yes, so I would say that it can be addressed, for example, by the Human Rights Committee, the Committee on Civil and Political Rights, the Committee on Economic, Social and Cultural Rights. But I'd like to bring up also a point that was raised. So it's about the state's obligations, but also, as Carol mentioned, business responsibilities. So I think in the case of these fishing fleet, I understand that they are state fleet, but in other cases, it may also involve private sector businesses. So I think making those links, bringing in also the committees of the International Labour Organization, so making the links between all the different mechanisms that exist, the human rights mechanisms, the labor, International Labour Organization, and their conventions as well, in order to improve the rights. I think, as Jamshid said, the efforts to come up with a solution really call for collaboration and for partnership among everybody. There are issues of the legal frameworks, the international legal frameworks, of knowledge of labor inspectors and awareness of labor inspectors to adequately identify and report human rights violations or report abuse. There are issues of environmental protection and environmental rights, security issues. So it's a very difficult question, but at the same time, it's a very good question to highlight how all the rights are interconnected and how we can identify maybe an opening. It doesn't have to be specifically with the ILO or with the CESC committee. We could identify an opening to talk about this. China very recently underwent a review by the Committee on Economic and Social Cultural Rights. So there is a follow-up to be undertaken. You can look at the concluding observations and see the issues that were raised, and perhaps there is an opening to address the committee with a follow-up report and say this specific issue of the right to employment and adequate conditions of work are being violated. So I think there are opportunities. In the case of the Chinese review under CESC, there were so many different issues. And as I mentioned, the concluding observations are really a roadmap. So the committee may have had to focus on the main priorities for the next 2 or 4 years. But that does not stop civil society from continuing its own monitoring, advocacy, and protection of human rights, and of documenting and then sharing its information with the committees. Thank you.
Many thanks, Remy. So we wanted to take the opportunity of the mandate of the UN Special Rapporteur on the right to food, and having Jamshid with us today to look a little bit more at the country level interaction. So I'm going to hand back over now to Jamshid.
Okay, so thanks. If there are no more questions, we continue to part 2. I'll start sharing my screen. I hope you can see it. And then I can't see it either. I'm trying to, okay. Can you hear me? Can you? Okay. So the second part is really focusing on how can we cooperate on country visits and how to send communications. I'll start with country visits, and I've been asked to maybe speak about a country visit to South Africa, because the Special Rapporteur on the Right to Food has asked to visit South Africa, and we have not received a response yet, so it's not confirmed, but we could really use that as an example if you think that's useful. So for example, just to start from the basics, each Special Rapporteur, they do 2 or 3 country visits per year to the country of the choice. And that's based on the invitation from the government. And there are 2 ways of doing that. Either the state has already a standing invitation, which means they are in principle willing to receive country visits from any rapporteur, and it's only a question of to agree the date. Or the second one is when the Special Rapporteur would ask for a visit and the government would have to agree. And the reason for that is that once the government agrees, the government would agree to really ensure freedom of movement, freedom of inquiry for the visit for the Special Rapporteur, but also freedom from retaliation to anyone who cooperates with the Special Rapporteur during the visit. So it's a huge undertaking because most of the governments are sensible to assessment from an external body. And I'm providing a link there in the TOR, which is terms of reference for a fact-finding mission, where you can open and see for yourself the terms of reference for a country visit once the government accepts it. And you will see that is quite a an undertaking for a government to accept it. And that's why it's not always easy to get the acceptance. It requires a bit of back and forth and negotiations. And during this country visits, that's an opportunity to really assess human rights situation within that specific rapporteur's mandate, and it creates a momentum for change. It's really an opportunity to show what is working well in the country, what are the concerns, and how they can be improved. And that is normally done in consultation with all partners. So we, as I've mentioned here, this slide, all branches of the government, of the state are involved. We're talking about the parliament, the executive part, the government itself, and we're talking about the judiciary. So the special rapporteur, for example, on the right to food would be meeting some parliamentarians, especially those who work, if there is a committee on food security or the committee on poverty, depending on the topics that has been identified for a visit. The rapporteur would be obviously meeting with the Minister of Foreign Affairs or Department of International Cooperation, for example, in South Africa, and ministries of agriculture, Ministry of Fisheries. So how do we know who to meet? And that's a question where once the country visit is confirmed, the dates are been accepted by the government, there will be an opportunity for the rapporteur to seek inputs from civil society, from victims, to say what are the issues that are actually of concern to them. And to also, the team will be making an assessment before even a country visit to understand what are the issues in that specific country. Are there any issues of discrimination in access to food? Are there any issues of specific vulnerable groups or groups in vulnerable situations, be it in rural communities or fishing communities, or maybe some minorities that are specifically exposed to risks? Are there any, for example, issues that the government, some certain parts of the government are not respecting human rights? Or maybe they're not doing enough to protect the communities or certain parts of the society from violations or from abuses by non-state actors, be it businesses, be it private security companies. So those are the questions that will be asked even before the visit. And based on those, there will be a program for country visits devised in consultation with the government. So the program for a visit normally, for example, if we have 10 days for a visit, there will be a program that takes care of official meetings with government officials, the judiciary, the parliament, as I've said, with the national human rights institutions, all the official parts of the government structure. There will be also part of the dedicated times for meetings that are not official, that are specifically targeting civil society, victims, communities, and so on. And there will be a lot of discussions. Normally, we try to encourage civil society and communities to work together to identify opportunities to really merge, sort of work together in solidarity and organize meetings, for example, focusing on certain areas or helping organize or represent the views of communities or organizations that may not be able to come and visit and see the rapporteur. The visit, in terms of places to visit, of course, we'll have the capital has to be a must place. For example, in South Africa, we are talking about the administrative capital. We're talking about Cape Town as a parliamentary seat. But of course, then there will be a question where else the special rapporteur would need to go to look into the situation in that specific area, because no country is, you would have a situation the same in the capital or in bigger cities as the same as in rural communities or coastal communities. There will be, of course, a sense of give and take, because normally within a week, 2 weeks, or 10 days, there is a limited time and logistical challenges in terms of to how many places you can go. So there will be a bit of an assessment and discussion taking place with communities or civil society in advance in terms of what are absolute places to go, and can we, for example, merge some meetings and try to bring several representatives to the same places and group maybe discussions so that we can gain time and make sure more meetings and opportunities are there for the victims. And of course, during this meet, there will be always prioritization to meet with the National Human Rights Institution In South Africa, it's a very good and strong institution. For just an example, I mean, there's so much work they've been doing both on food security, on the fisheries, but also more general on economic, social, cultural rights, that it will be a huge, it will be really a must to visit and see what they're doing and really discuss how that independent institution can help push for the right to food in the country. There is, of course, an opportunity to also to meet with the UN. There are some UN agencies based also in the country. There will be meetings with them as well. Sometimes when there is this issue of security concerns for retaliation, we try to organize meetings indirectly, and we'll pay attention to concerns of security and retaliation. Of course, that's very important. So security of individuals, their safety is important. So we'll have to really make sure that we don't do any harm during the visit. We are aware of the situation, and we'll do our best to limit that. And during this 2 weeks, once all of these places are visited, meetings have taken place, at the end, the rapporteur will have his preliminary observations that he will share with the government a day before a press conference, where he will basically read them out to the press, saying usually they will contain sort of the good things that the government may have done, some of the things that are maybe in the working, and of course there will be an opportunity to identify areas to improve. And there usually we'll have some agreements and disagreements with the government, but usually if they're based on evidence, on facts, and they're presented in a diplomatic way, and they're presented in line with international human rights law and national law, you will be a very sort of limited resistance or any limited reservations to those recommendations. And afterwards, as I mentioned here, there will be recommendations presented to the Human Rights Council in a country visit report. So if a visit takes place in May, as we plan, normally we would, the report on the country visit would be presented in a March session, the next session that the rapporteur presents to the Human Rights Council, March session 2024. And that is what we're hoping to do. And I'm hoping we will get a response. The latest we have from the South African government is that they are reviewing it, and that the Department for International Cooperation is positively looking at this opportunity, and they're just trying to coordinate with relevant line ministries like Ministry of Agriculture to see if they would be also available to host the visit. We are reminding them that it's a matter of urgency now, because we've only got a month and a half left to prepare, and these visits take a long time to prepare. So hopefully, once we get more news, we will be reaching out quite a lot of you, asking for input, suggestions, and maybe asking you to put us in touch with those that may not know us, to make sure that we prepare the country visits based on those ideas and inputs. The next part of my presentation is really on communications. What happens if a country visit is not possible? How else can you cooperate with the special rapporteur on the right to food, but also with other rapporteurs? It's the same method of work. You could actually use what we call communications here, which is basically, this is a tool to receive complaints of human rights violations and abuses, and to send those alleged violations to the government to clarify the situation and maybe provide information on any remedies that or any sort of actions they've taken to remedy the situation. Just to be clear, this is not the same complaint mechanism that Harumi mentioned about treaty bodies. These are not quasi-judicial procedure. The government, we cannot, special procedures cannot enforce their views and recommendations, but it's really the advantage is that it's very reactive, very operative action that can be taking place, and it's an opportunity for victims and for civil society and communities to really share their grievances and share their concerns. So the number of things to keep in mind. The special procedures or rapporteurs cannot really act on the situation without a complaint that is basically sent to him or her. So for example, we are aware for so many on the news, we receive a lot of press releases and reports about certain situations that merit intervention, that raises concern for the fisheries and the communities, but those cannot be acted for the purposes of this tool, because we need to receive a separate communication identifying the issues, identifying the situation, and asking special rapporteur or other rapporteurs, or collectively several rapporteurs, to act. And that's absolutely necessary by the code of conduct that I mentioned earlier, because otherwise the rapporteurs could just identify concern and act through a communication themselves. To prevent that, the member states have made it very clear that this is a reactive mechanism. It is reactive and is based on what the complaints we receive. And the complaints, once they're sent to government, the government has an opportunity to reply. And once the reply is received, then both the reply and the communication, they're public. And once they're public, it's an excellent opportunity for follow-up by communities and civil society organizations, because the concerns are there publicly. You can use it in the judicial proceedings that may be taking place in the country there where you operate. You may use it in your advocacy tools. You may actually use it in your follow-up meetings with government authorities, asking them for any feedback, for any follow-up that they may have taken. And this is an opportunity really to react, to take advantage on. This is a bit of a sort of the process. As I said, we need to receive the information. That information can be sent online, and I've provided the link in case if somebody wants to really send a complaint already after this training, you're most welcome. The risk, so there are several violations that we're talking about. The violation may have already taken place, it may be ongoing, or there may be a risk for it to take place. All of those are legitimate concerns, complaints to resend. If it took part, or if it's ongoing, or maybe there is a legislation that may limit, or it's not good enough, or it's not really pushing the human rights sufficiently, or it may be actually will undermine human rights. Those are all legitimate concerns that can be sent to a communication. Once the communication the complaint is received, the rapporteur reviews it to see if he wants to act on it or not. The draft is reviewed and sent. And usually communications are sent in 3 different ways: either urgent appeal, when we talk about death and life situations, where we're talking about urgent situations, and then or letter of allegation, that is the most sort of predominant case in most of the communications we receive. These are the allegations that are either have taken place or are taking place, or other letters that are mostly addressed to businesses or addressed to governments when it comes to legislation, draft legislation or policies. And here I'm sharing a link on communication database that you can actually click and search. I can do it maybe in the end, we can look at together. Before this meeting, I tried to search for communications on fishing, on the fisheries, and I have to admit, there are not so many. There are several, 1 or up to 5, and mostly dealing with indigenous communities, and that's interlinked between displacement and indigenous communities and the fishing communities. But a specific complaint or specific communication on the fishery sector, on the fishing companies, or on behalf of the fishing communities, I have to admit they are not sufficient. They are not sufficient to raise and bring sufficient attention of UN special procedures, of UN mechanisms to this issue. Earlier we talked about treaty bodies, UPR, we talked about OHCHR, High Commissioner, and special procedures. And in all of that, for example, when the complaints are received and the communications are sent to member states, once they're public, that communication is also shared with treaty bodies when they review a specific country. It's also shared with for the purposes of the UPR. It is also shared with the UN. So there is a lot more awareness of that specific situation. So I would only encourage to use this tool to make sure that there's sufficient attention is paid to the issues of the fishing communities. Who can submit information? Any individual, group, civil society, national human rights body that can submit information. that can be direct victims or indirect victims, or actually representatives of those individuals. We treat the sources of complaints as confidential. We will not disclose to the government or anyone from who we've received it. We have to receive the consent if the complaint is specifically referring to an individual or a group of individuals that may be identified, and if there are any risks, we may ask for consent. And it can be sent to any country, regardless of the ratification of any specific treaty, or if they exhausted or they have not exhausted a domestic remedy, which is really one of the criteria for the treaty body's complaints procedure. And you can send it in numerous languages, English, French, and Spanish. And I've here provided again online portal where you can send it, and you can send it by email if you have any, if there are any difficulties in accessing online portal or with internet. So here is just a process in terms of who is submitting, to keep in mind and describing the violation. And we do encourage not to be succinct, because we don't really need a lot of information. A couple of pages usually sufficient to describe the facts in terms of violation, where it takes place, by who, how, and when. These are the information that normally you would use in your press releases or in your specific case analysis anyways. And this is more or less what happens once we receive the complaint. And just to keep in mind, most of the cases when the complaint is received and any rapporteur decides to take the lead on it, there will be usually joint communication. As we mentioned earlier, most of human rights are interdependent. So for example, if you take any situation that you may send it to us, any complaint, normally it would be, if we talk about right to food or food security of a certain community, there may be relevance for the rapporteur on extreme poverty, there may be relevance for the working group on discrimination against women, there may be relevance for the rapporteur on environment and health. So there will be so many different sort of related areas for other mandate holders that we will encourage them to join, or they will take the lead and they will ask us to join. So it's really most special procedures that work in close coordination. So that part you may just keep in mind. You can address your complaint to several rapporteurs if you so wish. And here again, the reports as they're submitted to the council, an online communication database. And I've just shared the video on special procedures communications procedure, where basically a process, it describes within 5 minutes the way. It's a video that colleagues have basically devised to raise awareness about special procedures communications. I do encourage you to use it and share it to your communities and within your national human rights institutions, that to sort of demystify some parts of communication procedure. I would be happy to discuss any specific cases, I mean, examples maybe in terms of communications or country visits. If you have any specific questions, I'm happy to respond. So I'll stop sharing now, unless you want me to go to a website online communication database, which I'm happy to do. I'll just click on it. I can't resist the temptation. So just to show you, that's how it looks like. You can choose by country or by mandates, or even by groups, for example, African, Asia Pacific, or you can just really put the search team. If we say food security, and you can choose the date, and you will basically search, and this is what comes up. And just to give you an example, for example, Lebanon 2020, if you click on that, you will have full access to what was sent to that government. So that is an advantage of this procedure, that is all transparent, that anybody can access once it's public. With that, I'll stop, and I'm happy to engage more in specific issues. Over.
Thank you so much, Jamshid, and for your enthusiasm. And there's so much to learn here. Clearly, we needed like part 2 or another hour at least to discuss everything. And thank you also for the offer of follow-ups. And I propose that anyone in the room who needs to leave promptly, feel free to do so. I'm sorry that we've run over time, as always. But if you need to leave, please feel free to do so. I We have a commissioner from the South African Human Rights Commission on the call with us today. And I would like to invite a very brief 1-minute reflection, given the potential country visit to South Africa. If you're able to stay for a few more minutes, then we can have a few moments for questions from the room, please. So from the South African Human Rights Commission, please invite you to unmute, and yes, hello, welcome.
Thank you very much. And we are still afternoon in our country. I don't know whether should I say good morning to you or good afternoon to you as well. I will limit my comment to 1 minute as requested. I want to first of all introduce myself. I'm a commissioner at the South African Human Rights Commission. And then my focus area is called Land, the Right to Food and Environment. And as the South African Human Rights Commission, we are 8 commissioners, 6 are full-time, and then 2 are part-time. I'm one of the part-time commissioners because on the other side, I'm a solicitor or a lawyer, an attorney. Right. The South African Human Rights Commission is one of the state institutions supporting a constitutional democracy. And then we are empowered by a constitution, the supreme law of the land in South Africa, as well as an enabling act. It's called the South African Human Rights Commission Act of 2013. And lastly, another one which is called, the acronym is PEPUDA. It stands for Promotion of Equality and Discrimination of Unfair, Prevention of Unfair Discrimination. And then I want to be very briefly to say our mandate or the objectives of the South African Human Rights Commission are found in the Constitution as well as in the enabling legislation that I have just referred to. And very briefly, as the Human Rights Commission, we are supposed to promote respect for human rights and a culture of human rights. The previous speakers have been talking about culture. And secondly, to promote the protection and development of attainment of human rights. And lastly, to monitor and assess the observance of the human rights in South Africa. Now, let me focus on the right to food, especially to fisheries. Insofar as the right to food in South Africa, what I will identify as the most challenging or the main challenges in protecting the human rights of the small-scale fishers is the fact that they are indigenous fishers. And you find that because of the presence of some big firms or operations, they get removed or they get elbowed from where they've been doing this trade for some time. But then, as the Human Rights Commission, we are having 9 provincial offices because we've got we are a unitary state, not a federal state. We've got provinces in each and every province. Now, the provinces that are on the coastal lines, namely Natal, the Western Cape, and as well as the Northern Cape, that is where you find some complaints from the challenges that are experienced by the small-scale fisheries. I don't have the figures at the moment, but we collect them because we account to the Parliament, the Portfolio Committee of Justice, and then our reports usually will table the most complaints that we receive, and rotationally like that, and then also the complaints by the small-scale fishers, they do appear. And I don't want to be long, as you said, I must condense my input to 1 minute, but there is a lot that, as the Human Rights Commission is doing, is trying to ensure that these rights that are enshrined in the Constitution are protected. We are commissioners, we've got staff, but we also have some people who are assisting in other ways. You can call them as ambassadors. But then I will be amiss if I don't mention the fact that there are some other institutions that are doing almost the similar task in trying to protect the rights of the small-scale fishers. Thank you very much for the opportunity.
Thank you. Thank you very much, Commissioner, for those insights. I'd like to take 1 or 2 questions from the room, if we have any. Okay, 2 questions. Oh, really? Yes.
I hope you can hear me. I just have a couple of questions, but I'll try and condense them. I think they're mostly to Damshid, when he was talking about the roles of the special rapporteur. And first of all, I just think it's exciting to hear that, you know, there's this platform that exists, because I mean, as people that do a lot of activist research in small-scale fishing communities and dealing with the intersections between the issues that small-scale fishers deal with and other SDGs, like I think Elisa's presentation spoke about the different SDGs, because they're all interrelate with the realities of small-scale fishers, especially in South Africa, inequality being a huge issue that is historical and has perpetuated into the present, alongside issues of poverty, et cetera. So I think it is exciting to hear that when we deal with issues affecting the rights of small-scale fishers, especially from a human rights dimension, that the special rapporteur and this UN department are actually platforms that can be used to report some of the issues that are linked to human rights. But my question is around the special rapporteur, like for instance, coming to South Africa. I'm just curious, if they were to come to South Africa, who guides them in terms of the areas where they need to go, especially because, I mean, I'm sure South Africa is not unique in this, but small-scale fisheries is very different. It's not that homogeneous. There are many issues affecting different, depending on which province you are in. So if they're there for 2 weeks, I'm just wondering how are they guided in terms of the nuance that they can get that can be context specific. And my other question quickly was around if the special rapporteur is coming from an international human rights perspective, is there a platform initially where they engage with the South African government, relevant government departments that deal with food and fisheries, for example, and also civil society around sort of like a common understanding of what human rights are? Because in a lot of the issues that we deal with small-scale fishers, for instance, around customary rights, there are arguments by certain governments, departments, or officials that
where we've seen that customary rights are not seen as a human rights. But if, for instance, the special rapporteur argues that they are human rights, then there might be sort of a mismatch in terms of how human rights are defined. So is there a platform for some dialogue, like a high-level dialogue around what are human rights, and so to reach some sort of agreements? Because I think that might be an issue if in the country context, human rights, certain rights to fish and food are not seen as a human right domestically, but defined as a human right internationally by the United Nations. And just lastly, quickly, I was just wondering around, so if people do state their complaints, how does one deal with issues of intimidation that results afterwards when the rapporteur is gone? For instance, if people like basically say, oh, they are not happy with ABC, and maybe that appears in the reports that is written by the rapporteur. So if there's intimidation that results as a result of that from powerful actors, is there any support to people that are submitting those complaints? Thank you.
Thank you very much. This is, I'm Taryn Pereira. Hello? Yes. Okay, that's better. Sorry, I don't know if you introduced yourself, Pilile. So that was my colleague, Pilile Mbata from the One Ocean Hub in South Africa. And I'm Taryn Pereira, also from the One Ocean Hub in South Africa. It's really nice to see you, Commissioner Sibanyoni. A few weeks ago, we met with you with my colleague, Dr. Kira Irwin, and others, where we were sharing some of our experience with cross-cutting human rights violations that small-scale fishers face. And it was really positive for us to begin that dialogue with you and to explore ideas such as the task team that you spoke about, working on the right to food. And I just wanted to say hi and say, if indeed the special rapporteur does come to South Africa, that we would be very interested in working with you both around, as Pilile says, just sharing our own experience and also sharing some recommendations we might be able to make about small-scale fisher leaders and organizations who really should be included in this visit. So thank you.
Thank you very much. I'm going to ask Jamshid if you would like to respond very briefly to anything. I'm sure we could follow up afterwards if that's okay. But if you have a very brief response, in particular, perhaps to these first questions.
Thank you so much once more. I will try to be as briefly as possible. Let me start by saying, as the South African institution, the South African Human Rights Commission, we did send a report to the special rapporteur. And as the South African Human Rights Commission, we have been given an A status in the past, and it is our wish to maintain that status, the A status. And then I will also echo the sentiments that we are looking forward for the special rapporteur to visit South Africa, and we
Commissioner, you are muted.
Yes. Commissioner, we lost.
Yes.
Yes, you're back. You're back.
Okay. Lastly, regarding the question of customary rights, I think that that's an issue. As an institution, the South African Human Rights Commission, that we may escalate either to the Constitutional Court as the supreme court of the land. But in all respects, we perform our powers and functions as the Constitution says that we should do that without fear, favor, and prejudice. That will be an issue that needs to be escalated in future insofar as customary rights. Thank you very much.
Thank you very much, Commissioner. Jamshid, any final 30-second reflection?
Thank you. I mean, I think the Commissioner has done a wonderful job in outlining what needs to be done. And I think I hope once we get the confirmation from the government, we will be knocking on many doors, including the Commissioner's doors. Because precisely of this wonderful institution that has a status A, that means for many who don't know the Paris Principles, that means it's an independent institution from the government. It has the authority to sort of guide the government and report to the parliament in its independent capacity. So that's a huge resource for us during the visit. Also, we heard from One Ocean Hub that there have been many recommendations they've been making on the ground. There will be opportunities for you to submit and to provide us with guidance in terms of places. We are painfully aware about the diversity and the sort of in communities and the geographic plurality and such a huge country and beautiful country as South Africa. So we will have to really pull our brains to put our thoughts together with different stakeholders to identify how we can cover as much as we can within this limited of time. But if we can't, then it will be opportunity to share the issues. For example, we've already heard about customary norms. So we will need to be sort of getting more inputs to understand better if that's one of the issues that you think the rapporteur should be paying attention and asking questions for the government. On the point of awareness of how fisheries are connected to human rights, I have to admit, even international human rights, UN human rights mechanisms need to be sensitized. They need to be really educated in a good way about that, because if you look at economic, social, cultural rights, that is already a huge area of scope to cover for mechanisms. And if you look at the fisheries, there is a really little expertise among different mandate holders and treaty bodies. There are some experts that are willing to take on board. And what we need to do collectively is that we sensitize UN human rights mechanisms about this topic of small-scale fisheries, that we need to sensitize the governments. And then we need to sensitize national human rights institutions. And then we need to work together to see what are the issues that we can resolve collectively or individually, because we can't be doing every stakeholder or every civil society, community, commissioner, they will have some strengths and some advantages as opposed to others. And we need to really work on those opportunities. So we will be reaching out a lot in terms of, hopefully once the country visit is confirmed, we'll be announcing and we'll be knocking on the doors. I'm aware there was a comment based on the recent report by Massi Fundise, recent report on the small-scale fisheries. We've received it. We are aware of the situation, and these are exactly the type of reports and information that we would really encourage, that would raise awareness, and that would really be building that information and concerns from bottom up, and then we will be taking up. And if, of course, we will be discussing with communities, even if country visit cannot take place, if we don't receive the invitation, there are other opportunities to deal with specific situations. And I mentioned communications. So I'll be willing to engage with communities and civil society. We have a team who will be happy to train. If you're willing to write a communication, we're happy to take offline and work in a group and really train you how to write complaints, because we really need more complaints. And the governments, not only in South Africa, everywhere, they need to be receiving more complaints so they are more aware of the issues, because that's not a topic that is coming regularly to their attention. There are And that's something we would want to encourage. And I hope this is one of many opportunities. And that's really for organizers to consider maybe some areas for follow-up. And thank you so much for this opportunity and for the Danish Institute, for the One Ocean Hub, for FAO colleagues, and for the commissioner to come in person and to join us here. We will be reaching out, and if you need our help, please reach out. I'm happy to connect you with a special rapporteur or with other mandate holders that may be of interest or directly of relevance to your work. Over to you.
Thank you very much.
Thank you very much. Sophie from the Danish Institute, would you like to just say the final closing on behalf of the organisers today? Sophie?
Yes, hello. I think we have had a really good exchange today, and the time has run out. One highlight, if you are a civil society organization and you are very familiar with the SSF guidelines, but less familiar with where to connect to the specific human rights standards and instruments, I can really recommend that you check out the tool that Carol presented, because I mean, what you can really use the international and national human rights mechanisms is to be a support factor in the dialogue that you are having at national level with the ministries and with the states, so that you can really think of the NHRIs and the special procedures and so on as someone that can come in with an outside, but also with a human rights strong mandate to help inform the dialogue and to make recommendations. But their work is really not everything that counts. It's the follow-up to the recommendations that they are given is really what is needed. So look at the human rights actors as a friend that can help a dialogue, but the dialogue is really something which should come from the community, and where rights holders hold the states accountable to the obligations. So yeah, that's it from my side.
Thank you, Sophie. So we bring the session to a close. Apologies for running over again. There are clearly lots of things to talk about. We hope we can continue the conversation. Thank you to all of our online participants. Senya, please go ahead and bring the webinar to a close. Thank you.